Welcome back to This Week in Immigration. I'm Jordan LaPier. On the program this week, the acting DHS secretary resigns, a new effort to require migrants to purchase health insurance, and the latest legal happenings in Litigation Corner. All that's just ahead. Before we get started, please remember you can subscribe to this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or wherever you get your podcasts. And if you leave a review, it'll help more people find our show. You can also stream This Week in Immigration on our website at bipartisanpolicy.org/podcasts. And as always, check out bipartisanpolicy.org/immigration for more information on the stories we discuss here on the show. And here with me today are Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy. She's on Twitter at BPC_T Brown, and a happy Nats fan today.
Yes, I am. Thanks, Jordan.
And Cris Ramón, Senior Immigration Policy Analyst on Twitter at CRamonBPC. Hi, Cris.
Hey, Jordan. How's it going?
Good. All right, let's begin with one of the biggest stories in the world of immigration, and that's the resignation of acting DHS Secretary Kevin McAleenan. It appears he'll be heading for the exits at the end of October, having served as acting head of DHS for just about 7 months. Media reports suggested that even as DHS made strides in reducing the arrival of migrants at the U.S. Mexico border, McAleenan struggled to show the toughness on immigration President Trump wants in the position. So I'll put it to you both, your reactions to this development.
I have to say I'm not terribly surprised that he resigned. And I didn't think he was going to be long for the position. Kevin is a careerist, and he had started in CBP under the Bush administration, had been in and out of government. He was made acting CBP commissioner at the end of the Obama administration. He became confirmed CBP commissioner by President Trump. But he's not a political person. He's an operator, and was never going to be, I think, the TV voice that President Trump was looking at. With the shakeup at the department that resulted in the departure of Kirstjen Nielsen and the naming of Ken Cuccinelli, Mark Morgan into positions in the department, I think that sort of surrounded him with people who were much more hardline, much more of the Trump sort of visuals on immigration. But he was very active still in trying to negotiate with Central America. I think the one of the legacies he will have is continuing what Kirstjen Nielsen had started with building relationships with the countries in Central America and with Mexico in addressing migration jointly. It was just announced this week that the federal aid that had been cut off to those countries is now going to be reinstated because they have signed these agreements. And I think that's something that he worked very hard on. When the Bipartisan Policy Center hosted Mr. McAleenan when he was commissioner of CBP earlier this year, he emphasized very strongly how he felt like continued aid to the Central American countries to address the root causes of migration was an important contribution to managing the migration crisis at the border. That was an area where he clearly differed from the president. And so I think that that's one of those things that he probably feels somewhat accomplished for having done. That having been said, he also is somebody who signed the memorandum on family separation and carried out that policy in this administration. And so that will be part of his legacy as well. So probably the shortest tenure of any acting head of DHS, but he's also the fourth person to run DHS in the Trump administration. That is also a record.
I think for me, one of the things that, when you see these resignations, a lot of folks focus on the individual leaving, but they don't really focus on the other agencies that assisted with their tenure. And I think one of the things that isn't going to get as much attention is the role that Mike Pompeo and the State Department played with sort of helping McAleenan's work in Central America, sort of helping run point on helping, these agreements with El Salvador, Guatemala, Honduras, helping with those negotiations, helping with those discussions, really kind of helping support that whole movement forward to be able to advance the Trump administration's policies in this region. And in that way, I think it is a parallel with Nielsen's resignation that, once again, when she resigned, a lot of folks were focusing on her. But they didn't really focus on Jeff Sessions, who was the attorney general at the time, and the fact that he played a significant role in advancing zero tolerance, which led to the separation of families at the U.S. Mexico border. So for me, the reaction is always, it's not merely the person who's resigning, But, I think the focus is also is, sort of the other agencies that worked with them. That's, I think, a part of the legacy of that McAleenan and Nielsen left, having worked with those two separate executive agencies. So I think that's something else to consider. And like Theresa noted, I think the fact that McAleenan and Nielsen developed very close ties with the governments of the Central American countries, particularly El Salvador, Honduras, and Guatemala, really shows the fact that they were coming in with significant connections and deep ties to the region that I think is going to be very difficult to replicate if Trump decides to, bring in somebody like a Ken Cuccinelli type, who obviously is more focused on domestic issues, but may not have that foreign policy expertise or those chops that Nielsen and McAleenan had.
Theresa, you mentioned that McAleenan is the fourth DHS head to leave the post during Trump's time in office, which just hit 1,000 days last week. How big an impact does all of that turnover have on how the department functions?
Well, turnover at any cabinet level department is never great. Turnover in the top of the department is worse. And the fact is that there's only been 2 confirmed secretaries at the top of the department out of those 4. 2 were acting. And if you go to the DHS website now and you look at their leadership list, fully half of their senior leadership positions are acting positions. The deputy secretary at DHS is also acting. He's actually the confirmed head of the Transportation Security Administration, who McAleenan brought up to act as DHS deputy secretary, but there's no confirmed DHS deputy secretary. There's no confirmed DHS undersecretary for management. There's no confirmed DHS head of the Office of Policy. There is no confirmed heads of any of the immigration agencies, Customs and Border Protection, Immigration and Customs Enforcement, and U.S. Citizenship and Immigration Services. And so this is problematic for the, third largest department in the federal government behind VA and DOD. The largest law enforcement components in the federal government are in DHS. It has one of the broadest mandates of any federal government department for Homeland Security. And although all of the focus at DHS has been on immigration and the border, there are other key and really important mission sets at DHS that are probably getting less attention, less ability to function, and frankly, less leadership that need that to really move things forward. And so I think DHS is the youngest cabinet department. There are people for a while who have been wondering whether or not it was necessary to create DHS. Some people are calling for DHS to be separated and abolished. This is not good for this young department to have such turnover and such chaos at the top.
So that kind of confusion around who's in charge and all those acting folks at the top sort of scrambles the order for who would normally step into the acting role. So who are the administration's top candidates to replace McAleenan, and do any of them have a clear shot at taking the role?
So there are 2 aspects of this question. One is, who does the law say the president can name as acting secretary? And technically the law says that he can name as acting secretary another person who has served in a Senate-confirmed position, either within the department or elsewhere in his cabinet, for at least 90 days prior to the departure of the last confirmed secretary, which actually would have been Nielsen, not McAleenan, or certain other personnel. Both Cuccinelli has not been Senate confirmed for anything. He was appointed to a newly created deputy USCIS position because there was a career person in the deputy slot that could not be set aside. So they created a new position above the deputy USCIS director and named him to that so that he could be then acting USCIS director. The next person who could theoretically, easily, legally be named would be Pekoski, who's the TSA administrator, acting deputy secretary. That would be the next person. He has been Senate confirmed within DHS. Theoretically, the president could ask someone who's been Senate confirmed from another cabinet department to come over to DHS. That's theoretically possible as well. But the reality is that all the press and all the White House scuttlebutt is that he's looking to do something with either Ken Cuccinelli or Mark Morgan or both. The legal difficulties with doing that is that the administration would have to do extreme contortions, probably like they did with Ken Cuccinelli at USCIS, to try to make that happen within some plausible legal framework. The more contortions that they do, the more questions are made about whether or not that's a legal person in that position. And that is impactful for a major reason. If someone has been named to a position that they are not legally entitled to, any action by that person while in that position can be challenged in court, whether that is signatory to a piece of regulation, a policy, or even expenditure of funds. And that has already happened in the case of regulations published by USCIS and signed by Ken Cuccinelli, that advocacy groups have sued that he is not eligible to issue those regulations because he's not legally in the position. That is pending in some of those court cases. So this is a danger zone for the administration that has proceeded to implement its immigration policy almost exclusively by executive action, whether it be regulation or policy changes or presidential executive order carried out by any of these people. So that's something I think that the administration is going to have to look fairly closely at. They're going to have to weigh the president's desire to have somebody who looks and sounds tough on immigration but may not have the strongest legal case to be acting with who can get confirmed and or who can legally carry out all the things he wants to carry out. That's a dilemma for the administration right now.
What, if anything, does McAleenan's departure suggest about whether the administration plans to change its approach on immigration at all moving forward?
I think one of the things that we were anticipating with Nielsen's resignation was, at the time, essentially the question was, is DHS going to take a harder line stance against Mexico, El Salvador, Honduras, and Guatemala, especially in the midst of the large number of migrants who are arriving at the U.S. Mexico border in the midst of that extraordinary migration event. And what we saw is, obviously, the administration did go down that road, but it did create the space for McAleenan to still be able to operate in, I think, a fairly, in a collegial manner with his counterparts in those countries, and not in a terribly antagonistic way, to ensure that those agreements, for instance, were signed and that there was still cooperation. The question moving forward is whether or not that's going to be the case, where you're going to have maybe a harder line Trump stance, what we've been seeing with him with threat of tariffs or withholding aid, but coupled with a DHS secretary that potentially may also take a harder line stance just simply to reinforce what the Trump administration is doing. That's, I think, something that may impact how we interact with the region as a whole in terms of foreign policy. The one major caveat is obviously anything that's happening below political appointments. Obviously, DHS is going to be doing its work with its counterparts in these countries to implement these agreements, so that's always going to be happening. But that's a foreign policy. I think with domestic policy,
I'd say there's a couple of things to understand. McAleenan is departing at a time when migration at the southern border has dropped. It is still high by recent standards, but it has dropped precipitously. They seem to have a handle on what's happening down there. People quibble about how it's being handled and whether it's being handled correctly, but the urgency, the crisis mentality that came after the spike in March of this year has abated. And I think that means that for the administration, at least, the heavy focus on the border, one of the reasons Nielsen was pushed out, frankly, was because the numbers were high and the president wanted to bring them down. Right or wrong, McAleenan succeeded, at least in temporarily doing that. I think the issue is going to be, for Trump, what happens if those numbers start to spike again? I don't think it matters who he puts in charge. If the numbers start to go up, he's going to look for a change. He's going to look for a hardline position. He's going to look for action. And because that is how he is measuring his success at his immigration agenda, is those numbers at the border. Unfortunately, the United States doesn't have total control over what happens at the border. And I don't mean that from we don't control our borders. What I mean is that migrants who decide to come decide for many and myriad and their own reasons, and it may be a temporary pause to see how long the current situation and enforcement actions last, or they will find other ways to come through because the smugglers find other ways for them to come through. So pinning the success or failure of your entire immigration enforcement effort on a monthly up and down of numbers is kind of a dangerous game to play in terms of political success.
All right, on the other side of the break, the Trump administration tells migrants they'll need health insurance to get a green card. President Trump earlier this month issued a proclamation telling prospective migrants they'll need to obtain health insurance within 30 days of entry in order to get a green card. This is in line with what the administration has called its public charge regulations that seek to limit immigration to those who can support themselves financially. As with most things in the world of immigration, this action sparked support, criticism, and confusion over its legal justifications. So let's dive into the issues. Cris, walk us through what this proclamation says and what requirements it's placing on immigrants.
So the proclamation states that any individual who wants to immigrate into the United States from outside the country to get a green card, they need to have a healthcare plan. And when they're saying a healthcare plan, the proclamation actually goes into specific details to what these plans are. So, for instance, you can have an employer-sponsored plan. You can have an unsubsidized plan through one of the individual market exchanges in a state. Once again, that's unsubsidized, which is a really important point. You can have short-term limited duration health policies. You can even be on a family member's plan, and you could have visitor health insurance. But you need to have one of these types of plans in order to access the United States. And the effective date of this proclamation as to when you need to have that by is November 3rd, 2019. So that's kind of the basic gist of the proclamation. There are a few other interesting points that I think people haven't been paying attention to with this proclamation. One is if you circumvent these requirements, you become a priority for removal by DHS. The Department of State is instructed, or at least can outline agency level guidelines to implement this, given that the State Department is going to be reviewing a lot of these cases. And finally, it asks Health and Human Services to produce reports about the burdens that immigrants and other foreigners have on the healthcare system, especially ones that don't have health insurance. So that's kind of the plan in a nutshell.
So how is this effort going to impact future flows of legal immigration? Will this be a big deterrent?
I mean, we're looking at a significant number of individuals being affected. I think MPI did an estimate, I think over 300,000 individuals.
Yeah, about 65% of those in the recent years who have immigrated would not have met this requirement. I think it's especially going to impact those in lower wage jobs who are a lot of the family-based immigrants. If they're not able to get immediately on a family member's health insurance plan and their employer does not offer insurance, their ability to get an unsubsidized insurance plan is going to be difficult. And a lot of those short-term high-risk plans are quite expensive and they're very limited in their coverage. So I think that's what a lot of people are concerned about, is that this could have a pretty quick, immediate effect on a lot of those family-based sponsorships.
Yeah, because I think one of the things is right now, since public charge, and we'll talk about this in the next segment, is sort of in the courts. Obviously, this will be litigated. That's an obvious point, as we've seen with advocates and the policies that the administration puts out. But at least in the near term, if this goes into effect, that it really could deter and impact the number of individuals who are coming here in a green card, and just sort of falls in line with what the administration's been doing with legal immigration.
This proclamation invokes a presidential authority to restrict immigration on national security grounds, but some legal experts find that claim pretty dubious. So what are the legal issues or questions here?
So the basis for this proclamation, and I should back up a step and say this is a proclamation, it's not an executive order, and it's different from the public charge regulation, all of which are executive actions. But this is a proclamation under Section 212F of the Immigration and Nationality Act, which says that the president has authority to restrict or bar entry into the United States of any foreign national, pretty much for any reason if he deems it in the national interest to do so. This is the legal basis, for example, on which the travel ban rested, that the Supreme Court ultimately approved in its fourth iteration. And that's probably why the president is using this legal avenue to try to implement this policy, because it was upheld, at least in theory, in this other case before the Supreme Court. But as you mentioned, past uses of that authority have pretty much been restricted to national security type situations or law enforcement situations. The president is not arguing that this is a national security issue. He is saying it's in the national interest. And the argument in the proclamation is very similar to an argument in the public charge rule, which is that immigrants who don't have health insurance are a drain on the budget and taxpayer of the United States, and therefore it's in the interest to keep them out. This is a novel argument, probably for the 212F section of law. As Cris said, it most certainly will be litigated. We're aware of several organizations that are already looking at litigation against this. But I think that raises some questions. There's also been questions by internal lawyers for Health and Human Services that run the Medicare and Medicaid and exchanges as to whether or not this is legal under other laws, under equal protection laws or healthcare laws that we have in the United States. So I think that we have to wait and see, like everything the president does that is subject to legal challenge. We'll see what the courts do with this. But it is a pretty extraordinary use of this particular part of the immigration law and presidential authority.
Okay, don't go anywhere. When we come back, Litigation Corner. Finally, today, it's Litigation Corner, where we cover major developments in immigration policy lawsuits and provide quick analysis. For each case, we'll cover why the case is significant, what the judge or judges said, and what happens next. All right, today we have two cases, or really kind of two bundles of cases to review. First up, nearly a handful of judges across the country have now fully or partially blocked the Trump administration's so-called public charge rules from taking effect. Those rules would prohibit visa or green card applications from those who the government suspects might be dependent on public benefits. Theresa?
Sure. So we have at least 4 courts that have issued injunctions in New York, Washington State, Chicago, and San Francisco. 3 of them are nationwide injunctions. The 4th in San Francisco just applied in the Ninth Circuit area. But since we have 3 nationwide injunctions, the public charge rule, which was scheduled to be in effect as of October 15th, is now blocked from being implemented. So that rule, which had an awful lot of court cases, it was 21 states plus the District of Columbia had filed suit on this, plus a lot of localities, cities, immigrant servicing organizations, healthcare providers, a whole lot of folks engaged in these lawsuits against the administration. So this is a pretty significant win, if you will, for the advocates, a pretty significant defeat for the administration, because this public charge rule was one of those signature rules that the administration had really pushed for. I would note also that as of yesterday, at the recording of this, there was a 5th lawsuit filed in the D.C. Circuit over the fact that, in spite of that this rule was supposed to go into effect on the 15th, as of the day before the 15th, the new required forms had not been published. And so the American Immigration Lawyers Association filed another APA suit against the government for not having the forms available in time. But of course, that's all moot now because of the injunctions.
So, I mean, this is really significant because, we were talking about this before we recorded this podcast of which Trump administration or piece of policy has been litigated multiple times. And this is, I think, is definitely in the top 3. Advocates have definitely been wanting to target this for a long time because, in their view, this would severely restrict legal immigration to the country. And there's studies and research that backed it up. So the fact that, several courts really came out swinging against this policy, for lack of a better phrase, really is a major setback for the Trump administration's policies and its efforts to reform the legal immigration system in its own image. It is entirely true that this definitely would restrict legal immigration, and it's a question of whether or not you agree with the administration's efforts to say we need higher skilled or better educated immigrants coming here, or whether you believe that the legal immigration system should accept a large number of people from different backgrounds. But at the end of the day, I think this isn't the end of this litigation process. I think that this will definitely be appealed. But there's going to be a lot of appeals, and obviously because there's a lot of cases to move up.
Yeah, I mean, the administration has shown a propensity to ask the Supreme Court to rule early on these kinds of cases. My guess is that they will go to the Supreme Court as well and say we have multiple lower district rulings and we want to, get these injunctions lifted. We'll see if the Supreme Court agrees to take that up, but that would be the next phase in that litigation.
All right, and second, a federal judge in Texas also ruled against the Trump administration's national emergency declaration, which the administration had sought to use to build the long-promised border wall by repurposing money from other federal projects.
So this was interesting. There had been a previous court case in California that had blocked the use of Department of Defense funds that the president had moved to build the fence. The Ninth Circuit blocked Circuit Court of Appeals confirmed that injunction, but the Supreme Court, if you remember in July, said, nope, we're going to let this go in effect and lifted that injunction. Now a judge in Texas has not issued an injunction, but a summary judgment in favor of plaintiffs who argued that the emergency declaration was patently against the Consolidated Appropriations Act that Congress passed and therefore was illegal. That is not an injunction. That is a ruling on the merits, a summary ruling in favor of the plaintiffs in this case. And it does block any movement of these funds under that emergency declaration and any building of any additional walls anywhere along the U.S. Mexico border. And the fact that it came out of a court in Texas, I think, is pretty significant because that's usually considered more conservative territory. So we do have to see, obviously, like everything else, this is one will be appealed. I also note it's that just today, the president vetoed the second resolution of disapproval that was passed by Congress, both the House and the Senate, of the emergency declaration. So the president clearly is going to appeal this one. He believes that he was in the right, in spite of what the courts or Congress is telling him.
I mean, obviously, this is also significant because this has been the president's, principal campaign item during his 2016 presidential campaign of what he was going to do with immigration. And the administration certainly was very happy when the Supreme Court came in and lifted that injunction. Then they started declaring victory. Obviously, they celebrated a little bit too soon, and now we've got a situation where potentially any type of funding that they're trying to use for the wall will be severely restricted. And it's interesting because right now you're seeing the administration really trying to tout the progress it's making on the wall and has made building that wall, a principal goal for the 2020 presidential elections. But the thing is, obviously, if you have this court case that's obviously very much in the middle of everything, it's going to make it a lot harder. Of course, I think there's other things to consider with building the wall. And for instance, in Arizona, we've heard reports about Native American tribes and environmental concerns also playing a role in sort of slowing down the construction of the wall, or at least things to be considered. So I think that this is going to continue to be litigated both in courts and the court of public opinion.
Yeah, one last thing I just would want to say that government funding runs out November 21st, and one of the big controversies in continuing the government funding for the current fiscal year is once again border wall funding. So this will play out again in Congress.
All right, Theresa, Cris, that's, I don't want to say a good place to leave it, but that's where we're going to leave it. Thanks as always for joining me. We'll be back in 2 weeks. In the meantime, please take a second to find us on Facebook by searching Bipartisan Policy Center or on Twitter at BPC_bipartisan. And don't forget to subscribe and leave your feedback on this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or wherever you get your podcasts. Just search Bipartisan Policy Center. This episode of This Week in Immigration was written by Cris, Ramón, and myself and produced by Yafat Tawahara. That's all for now. Join us again next time on This Week in Immigration.